The proceeding will start shortly. 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 The proceeding will start.
The petition being debated today was started following the sad murder of Jade Ward last year. Sentencing in that case has now concluded. However, I remind members that they must not refer to cases that are currently before the courts and should be cautious in referring to any cases where proceedings may be brought in the future. I now call Mark Tami to open the debate. Mark Tami to move the motion.
I beg to move that this House has considered Petition 614893, which calls for the automatic suspension of parental responsibility for any parent found guilty of murdering the other during their period of imprisonment. Thank you, Mr Hollowbone, for giving me the opportunity of taking part in this important debate today. And firstly, can I place on record my thanks to Jade Ward's family and friends, and in particular Edwin Duggan, for their dedication and work in putting together this petition, which has received over 130,000 signatures, which is a remarkable achievement in itself. At the heart of today's debate is the life and memory of Jade Ward. Jade was an enormously loved mother, daughter and friend. She has been described as a sunshine in the lives of all who knew her, bubbly, kind and caring, and she was truly devoted to her 4 sons. The last days of Jade's life were spent caring for her grandmother as she recovered from surgery, laughing with her friends in her garden and providing for her children. These final moments typify the life that Jade led and the kind person that she was. On August the 26th, 2021, Jade was brutally murdered by her estranged husband, Russell Marsh, in a premeditated attack. On April the 12th this year, Marsh was given a life sentence with a minimum of 25 years in prison. After Jade ended their relationship a week before her murder, Marsh had reportedly told friends that if he couldn't have Jade, no one could. Marsh was a controlling figure throughout their relationship, who would tell her who she could see, who she could speak to, what she wore, what she could do. And when Jade stood up to this, she was killed as a way of punishment. Jade was just 27 and lived in Shotton. She had 4 children with Marsh, and as they slept nearby as their mother's life was taken away from her, Despite these utterly distressing circumstances, Jade's family were horrified to learn that they faced the prospect of continued contact with the man that murdered their daughter. Although it is obvious that Marsh will not have custody over the children whilst he serves his time in prison, despite all his appalling actions, under law, he still retains parental responsibility. Jade's mother, Karen, said she was absolutely gobsmacked to hear that her daughter's killer could still have a say in the boys' lives. And Mr. Hollowbone, I think if you walked out on this street or any streets today and talked to people and told them what the law says, I think they would be gobsmacked as well, that that's how the law works. So what exactly does the law say about this? When a child does not have a parent to care for them, local authorities have a duty to safeguard the child and find an interim or a permanent care arrangement. The child's relatives can seek a court order to care for them. Local authorities can initiate proceedings with a view to providing the child's upbringing, or carers can achieve parental rights through a special guardianship order. Importantly, where two parties have parental responsibility, one party cannot make decisions unilaterally. They must seek the other party's agreement. Responsibility is automatically equal. So in law, neither party's parental responsibility is considered more important than the other. That even stretches to the most extreme cases where one parent has been convicted of murdering the other. I understand Jade's parents have been told that if they want to take their grandsons on holiday abroad, they would need the permission of the father. A convicted parent must also be consulted on issues such as where they go to school and the medical treatment that they receive. Effectively, Marsh has the right to veto decisions made by Jade's parents and pursue a family court hearing. Now, I think we can only imagine how traumatic this must be for them. And having already suffered the terrible pain of losing their daughter in the way that they have, the process as it stands compels them to interact with their daughter's killer like this. And it acts as a constant reminder of one of the darkest, or probably surely the darkest moment in their lives. As with Jade's boys, often children will be in the care of the family of the deceased parent. And so the current process effectively grants the convicted parent the means to continue the control and coercion of the family in the same way they did prior to the murder of the victim. I will give way.
Thank the Right Honourable Gentleman for giving way and the powerful speech that he's giving. Do you agree with me that a word like re-victimisation isn't too strong a word to describe what would happen to the family in these circumstances?
I think it is, because I think it just doesn't stop. There is no chance to move on. Not that it would ever be easy to move on, but it gives, in some ways, the convicted person even more weapons to use against the family of the deceased. And we all know it can be, and it must be, extremely traumatic for the children to know that the person who killed their mother or their father know so much about their lives, particularly when the children witnessed the murder. The law surrounding parental responsibility, to my mind, is clearly not fit for purpose and facilitates further unnecessary emotional trauma. Helping to fulfill the desire of the perpetrators with a history of domestic abuse to practice their controlling and psychological abuse from inside their prison cell. Now, we often see domestic abuse as physical violence, which it is in many cases. but at its root is control. It is about controlling their so-called partner. And to give that person still that control from the prison cell must give that person, that perpetrator, a real buzz to still carry on and be able to do that. So, if parental rights are by default retained, and even in the most horrific of circumstances, when can they actually be restricted? Now, the Children's Act 1989 allows the guardian or holders of the residence order to go to a family court to bring a prohibited steps order against the person with parental responsibility. But the onus is still on the family to prove why parental rights should be revoked. It is expensive, time-consuming, and, of course, an emotionally draining process for the families who have got to come to terms with the tragic loss that they have just experienced. That's why Jade's family, Karen, Paul and Pip and their friends, are campaigning to have the parental responsibility of a parent who is found guilty of murdering the other parent automatically suspended. I will give way.
I'm very moved by his speech, and as someone who brought up a child on my own, I often worried what would happen if something happened to me. So would my right honourable member agree with me that this current system in place is failing to put the child at the centre of the legislation?
I would agree, and I will go on to talk about family courts as well, which I think that in some ways really shows what some of the problems that we are and the lack of connection between what happens in other courts and what happens within family courts. And I think we have seen in this case, and indeed many other cases, where the children could be effectively weaponised by the person who has committed the offence to carry on that control, that abuse. So, as mentioned, currently the onus is on the family to prove why Marshy's parental responsibility should be revoked or restricted, whereas Jade's law calls for parental responsibility to be automatically suspended in circumstances such as these, putting the onus on the killer to go through the legal hoops of proving they deserve parental responsibility, freeing the victim's family of the traumatic burden that they currently carry. As Jade's mother said, we're going through enough without having him looming over our heads. And I think, Mr. Hollowbone, that really sums up the actual situation we find in the law today. And unfortunately, they are not the only ones. Ahead of this debate, the chair of the Petitions Committee spoke to survivors of domestic abuse who are experiencing ongoing issues relating to their ex-partner's retention of paternal responsibility. Their experiences highlighted just how far our laws on parental responsibilities and the family court system are failing children and victims of domestic violence. One issue that came out strongly from the discussions was that violence committed against a parent is not distinct from violence against a child. Indeed, allowing a child to witness or be surrounded by violent behaviour is inherently abusive in itself. A parent's willingness to subject their child to this surely calls into question their ability to act in that child's best interests. And yet women who spoke to the committee felt the family courts just don't recognise this. Despite all the convictions of traumatic, sexual, physical and emotional abuse, the threat these men pose to their own children's welfare doesn't seem to be acknowledged. Over and over again, the committee heard that the abuser's right to be a parent was prioritised over the children's right to safety. A woman whose former partner was convicted of sexual abuse offences asked why, and I think it's a perfectly reasonable question, he should be allowed to access their children when he was considered to be too dangerous to work with or be around other people's children. For victims of domestic violence and for families who have lost loved ones to an abusive partner, the criminal justice process is often just too traumatic. Not only are they forced to relive simply harrowing experiences, but they have to come back into contact with a person who was responsible for doing them in the first place. You would think that once proceedings have ended and a criminal charge has been made and proven, they could begin to move on. But since family and criminal courts are distinct from each other, victims are forced to restart this emotional, burdensome process to restrict parental rights. One of the women who spoke to the chair of the Petitions Committee found the family court system itself to be abusive. With renewed contact with her ex-partner, it became a new avenue which he continued his controlling behaviour. That family courts are not equipped to deal with traumatic cases of murder and domestic abuse was a common opinion that came out. Both Jade's family and the women who spoke to the chair of the Petitions Committee also emphasised the financial pressure posed upon them by the current system. Pursuing a case in a family court is expensive, and the lack of funding for legal aid, as we all know, is a long-standing issue. Victims and their families are forced into thousands of pounds of debt to restrict parental responsibility or face the other choice, which is to compromise on the safety of their children. Since the very beginning of the Families Campaign, the government has stated that there is already scope for courts to exercise power to effectively remove all parental powers and authority in appropriate cases. But, Mr Hollowbone, I think the government are missing the point. Jade's family and friends are already aware of the law as it stands and the current process of restricting parental responsibility. But they are saying, and we are saying, that that process is wrong. The onus should be on the convicted murderer to prove that they have parental responsibility, they should have parental responsibility, rather than on the family to make the case why they shouldn't. Jade's law would be simple, common sense way of shifting the burden away from a victim's family and friends who have already suffered the anguish of murder of their young one. Jade's law can put an end to the endless cycle of psychological torment, lengthy and costly court processes, and the constant harrowing reminder that the current system forces upon them. But let's just be clear, Jade's law does not demand the automatic removal of parental responsibility for cases such as this. It demands its automatic suspension, giving the opportunity to the perpetrator to go through the legal hoops themselves to proving that they are entitled to those parental powers, proving that they have changed their ways, proving that they have admitted to the crimes that they have committed, and they have gone on a long journey to prove that they have the right to be involved in their children's lives, not the other way round. And the petitioners also recognises that there are nuances. For instance, it's recognised that some specific circumstances whereby it would be right to exempt someone convicted of killing the other parent from an automatic suspension of parental responsibilities. These would include where a convicted person can prove that there was a history of domestic abuse in their relationship, and that although the murder cannot be condoned, the murder trial concluded that there was provocation and it was a mitigating factor. However, the principle of shifting the burden of proof is a key message that we are sending to the government today.
Just to expand on this, it's a very interesting idea. Does he envisage this being something like akin to a parole board where somebody would go and fight their case for early release as happens now? Or would there be some additional kind of legal process? Would he have to go back to court again to fight for his rights?
I would just, as I said, believe it should be turned around the other way, so that it would be the onus on the person who is convicted of going through the same process that effectively the family is forced to go through now. Now, I am delighted that our front bench supports this change, but I don't want this to be a party political matter, because I don't think it is. And I don't think anyone in this room today, regardless of what party they are from, probably in their heart of hearts, would stand up and defend the current system and say it's absolutely fine, and I don't know what the fuss is about. And I'm sure if we went out, as I've said, on the streets, again, there would be almost everybody would say that seems the correct thing to do. So I hope we can move forward across the House to find a mechanism adding to existing legislation, such as the Children's Act 1989, whereupon a person with responsibility who is found guilty of murdering the other parent would have their responsibility rights automatically suspended throughout their term of imprisonment, again passing the burden onto the convicted person. Now, I know we will have, and I'm not prejudging what the Minister is going to say, but I'm sure his officials have said, as they always do, regardless of that this is very difficult, this is going to take a long time, we can't do this, we can't do that. Now, I've always been a believer where there is a will, there is a way. And I'm sure the appropriate legislation can be found, that can be amended to make sure this actually happens. And I actually believe that the implementation of Jade's law would not add additional costs to the public purse. And it may, in fact, save local authorities money, who would no longer have to send social workers to visit convicted parents in order to obtain permission for things. A cost-free, even money-saving reform to relieve the traumatic burden the families of victims currently carry is the morally right thing to do. And to me, it's simple and common sense.
Would you give way?
I will give way before I conclude.
I thank the Right Honourable Member for giving way, because I wanted to make the point that when I had an issue with my constituent over the parental rights of a parent who was a convicted sexual offender of her children, and this was a very, very similar case, and it was horrific, but I'd just like to pay tribute, because this is cross-party, and I do appreciate at that time the Right Honourable Member for South East Cambridgeshire did make change happen and was very supportive. So I do urge the Minister to be able to make that change happen today for Jade.
Thank you, and I obviously share those words as well. So, Mr Hollowbone, to conclude, I want to read a statement issued by Jade's parents after their daughter's killer was sentenced. It said, "Jade was the sunshine of our lives. She was the glue that held us all together. She was a devoted mother who would do anything for her children. A much-loved friend, daughter, sister, auntie, niece and granddaughter. Jade's whole life was ahead of her, and her death has left a void in all our lives. Sadly, it is too late now for Jade, but her children and others in the same situation still have their whole lives before them. We owe it to them to ensure that the system is on the side of the victims." Thank you, Mr Hollowbone.
The question is that this House has considered E-petition 614893 relating to suspension of parental responsibility for people convicted of serious offences. Sarah Atherton.
Thank you, Mr Hollowbone, and it's a pleasure to serve under your chairmanship, and I'd like to thank both the Right Honourable Member for Allen Deeside and, of course, the petitioners for bringing this important debate here today. Of course, I want to extend my heartfelt condolences to Jade's family and thank them for their bravery in advocating for change at such a tragic time. Looking at the list of petitions and signatories by parliamentary constituency, Chair, that there is clearly a strong geographical centre of support in North Wales and just across the border, with strong pockets of support from Devon, Vale of Clwyd, Ellesmere Port, Chester and, of course, Wrexham. 878 people in Wrexham signed this petition, but I have absolutely no doubt that support for this petition and its aims extend right across the country, cross-party and cross-border. And I just wanted to touch on a few points. Firstly, I note in the initial response from the government that under the Children's Act of 1989, parental responsibility can already be lifted by the court. This is a mechanism, there is a mechanism in this Act that allows for the member of a child's family to care for that child if they are found in a situation where there is no parent to do so on a day-to-day basis. And I am pleased that this safeguard and option is already in law, as it should be, but I think the law can go further than that. The concern I have, and I understand, is that firstly, obtaining this legal status is both lengthy and expensive. And secondly, as a direct result of this lengthy process, parental responsibility remains with the perpetrator if a crime has been committed until the process is complete. For example, if the process for obtaining what I understand is called a special guardianship order was less time-consuming and less expensive and less onerous on the family members who are honourably trying to do the right thing in difficult circumstances, then we might not be requiring an automatic removal of parental responsibility, which is being debated here today. Whilst different to Jade's law, I do have some experience with my own constituent who is trying to obtain an order to take over parental responsibility for their grandchildren in the absence of parents who are present and able to parent. The case of my constituent has highlighted to me the process of obtaining guardianship of her grandchildren and how difficult and expensive that process is. And my understanding is obtaining a special guardianship order can cost thousands and thousands of pounds, assuming the parent gives consent in the first place. This is the exact opposite of what we should be trying to do and what we should achieve. Where there is a family member who is willing and able to take care of children, we should be supporting them to do that, not putting up barriers in the way. We shouldn't be making it more difficult for children to be looked after by their family rather than the state. Firstly, this is the best and safest option for children to be cared for by their family, who already know them and they know their routines. And secondly, a child being looked after by the state, that should never be the preferred first option. At the moment, as the process stands, it makes it easier for children to be looked after by the state and at significant cost than members of the family. And in my view, and the constituents of Wrexham, this is wrong. Of course, safety and well-being of the child is always paramount. Having been a nurse and social worker for 27 years, I have first-hand experience of children being removed from their homes and placed in temporary accommodation, lasting year upon year. I know from many years of seeing this, there is no substitute for a child being raised by their family in a safe and loving home. If this can be accommodated and all necessary safeguards and checks have been done, it absolutely should be. Of course, there should be a presumption that if one parent murders another, then parental responsibility is removed. The concern I have with automatically removing parental responsibility is that we need to have processes in place to deal with the gap in care and the decision-making. At the moment, the process for handing parental responsibility over to family members is too laborious, costly and stressful. We need to make allowances for that or make the process easier so that children aren't automatically cared for by the state when they don't need to be. Local authorities need to be more supportive of families applying for a special guardianship order. However, where the state is needed, remembering health and social care is devolved in Wales, the Welsh Government needs to ensure that councils are adequately funded so that children always have timely and appropriate care and they don't fall between the gaps. Where there are family members who are fit, willing and able to make the decisions for the children, that should always be the priority. Thank you, Chair.
Just working out which mic was going to come on. A pleasure to see you in the chair as always. And I thought the Honourable Member for Wrexham made some interesting points, and the all-party group on kinship care has done a lot of work on these issues, and very much that chimes with some of the things she was saying. I do thank the Right Honourable Member for Allen and Deeside for opening the debate on behalf of the Petitions Committee and for sharing the experiences of Jade Ward's family. There are no words to describe the pain those close to her have been through, but he has done an excellent job of articulating their calls for action, and it can't be easy for those of them that are present here today to have to listen to this debate, but I hope they feel some reassurance that something might come for it. I know often people who've been through very difficult experiences do get some strength from the idea that something good may come of the pain that they've been through. It's often assumed that a legal mechanism is automatically triggered when one parent is sentenced for a serious offence to assure the safety and well-being of their children as well as those looking after them. But as we've heard today, that just doesn't happen. When a parent goes into prison, if they've got parental responsibility, they retain that by default. Caregivers must consult them ahead of key decisions concerning the children's name, where they go to school, their religious upbringing, and any medical procedures they undergo before their 18th birthday. Where parental responsibility is concerned, the law does not differentiate between parents who commit non-violent offences and those guilty of serious offences, including murder, rape, sexual offences against children, gang-related violence and similar. This is even the case, as we've heard today, where one parent has killed the other, or where that parent in prison has killed another family member. Understandably, today's petition is focused on parental homicide, or interparental homicide, and that is where we should start, I think, in terms of reviewing the law. But there's also many other cases that are brought into similar sort of scenario. Far too many parents are having to keep contact with their abusers for their children's sake. I say for the children's sake, but that's based on a default presumption that it must always be in the child's interest for the parent in prison to retain contact, and quite often this presumption is wrong. The only mechanism a child's primary caregivers currently have to challenge the perpetrator's right to parental responsibility, as we've heard, is through the legal system, and a court can terminate a father's parental responsibility on the grounds of their behaviour. But this only happens in exceptional circumstances where there's proof that the father retaining, I say father in terms of shorthand, retaining it would be detrimental to the child's welfare. And as I understand it, this has only ever happened 4 times in England and Wales. Families aren't always ready or willing to put themselves through the extra trauma of attending a court hearing, having to relive the worst time of their lives and having their version of events placed under the microscope yet again. Facing the person who killed or abused their loved one or abused them and looking them in the eye is often very difficult. They might also be fearful that the perpetrator will retaliate in whatever way they can if the court removes the rights, especially if they are going to be released from prison before the child turns 18. It does take a lot of courage to take a violent perpetrator to court, knowing the risks, and it's easy to see why many would be put off attending court at all. And as we've heard, spiralling court backlogs, cuts to legal aid, only make this process more agonising for the families. The main thing I wanted to talk about today, though, is the work of the charity Children Heard and Seen. It's a charity that supports children with a parent in prison. And the primary focus, and this is what differentiates it from other charities, is that they focus on what is in the interest of the child. And a lot of organisations that work with prisoners' families, it's very much about the rights of the prisoner and an assumption that contact with the family is in the prisoner's interest, because we know that, for example, that means the risk of reoffending is far less. It often shocks people to learn that there's no system for recording when a child's parent goes into prison. Sometimes it is picked up in pre-sentence reports, although sometimes the parent won't admit they've got a child because they're worried about it being taken into care. Social services might already be involved with the family, or it might become involved if it's suspected the children are the direct victims of the parent's crime, such as child sexual abuse. But often you find social services, once they realise that the children weren't the victims and perhaps other children were, they just disappear from the scene. There's no system for routinely informing children's services at the council or the children's schools, or for monitoring the children's well-being during a parent's imprisonment. The data is very hard to come by. I have seen, there's a figure that's used quite a lot of 312 I was getting my nose, 312,000 children being affected from year to year. I think that's probably on the high side, but it's just impossible to tell. Many children are off the radar despite potentially being at risk or very vulnerable and needing support. Children Heard and Seen, the charity I mentioned, run a support group for carers looking after children affected by interparental homicide. They also support families who continue to experience harassment or coercive control, despite the perpetrator being in prison, so that would include domestic violence cases as well. I've heard from them of the strategies domestic abusers use to manipulate their ex-partners while in prison, from using illicit burner phones to breach restraining orders, to refusing divorce papers, to getting friends or neighbours to harass and intimidate them. Services supporting victims might tell them they're safe once their former partner is in prison, but this isn't always the case. Children Heard and Seen say allowing a violent offender parental responsibility gives them the opportunity to control their child, ex-partner or family from within the prison walls. One mother, for example, actually I would say on the Children Heard and Seen website, there are a number of blogs from people who've been affected from having one of the parents go into prison, whether it's the child themselves or the partner that's blogging, and there's quite a few accounts of this. But to just cite one case, one mother applied for passports to take her children on holiday after a difficult few years leading up to their father's imprisonment. But because both parents had parental responsibility, she needed his signature to complete the application. He was given the paperwork by the prison officers and he refused to sign it. That meant the family couldn't travel and the mother lost every penny she'd paid towards the holiday. Of course, their father wouldn't have been able to join them on holiday, but it wasn't about the children at all. It was about another way to pull the strings of his family life, to exercise control over his former partner, despite the physical distance between them. A perpetrator of domestic abuse might be restricted from contacting their actual victim, so say the mother in this case, if there's a restraining order in place. But if they have children together, it's very easy for them to use that child as a way of still being present in the abused partner's life. Little can be done to stop them from calling or writing to their children. Family services, as I've said, often encourage prisoners to stay in touch in such situations because it's seen as in the prisoner's interests. And, you know, again, it's nobody really... There's just this belief that a child must want to see their parent who's gone to prison. They must be missing them dreadfully, despite having witnessed a lot of abuse of at home and actually being quite fearful about the parent and in some ways, you know, quite relieved that the parent has been removed from the household. As I said, they can use this contact. They can say, well, I'm only going to see the children if you bring them, if the mother brings the children to the prison, and if the child does want to see the parent, that's a way of exercising control. They can make veiled threats through written letters. I just can't imagine how chilling it must be for an ex-partner to have to read out to their children letters that their abuser has actually written to them. Letters saying that he's getting stronger in prison, he's counting down the days towards seeing their mum again, even containing drawings of the children's favourite film characters holding knives. We need to see a case-by-case approach where services work with families to take a more active role in determining when contact is appropriate. As of 2019, men make up 95% of the prison population. Far higher proportion of men obviously in prison for serious offences, so it's fair to assume that far more fathers are in prison than mothers. But the flip side of this is there's an extra level of complexity if a mother is arrested for a serious offence. Societal expectations about mothers' natural role as a primary caregiver can lead to the assumption they should automatically keep parental responsibility. And courts can't, as I understand it, legally terminate a mother's parental responsibility, but in rare cases this can be limited. So just to conclude, Mr Hollowbone, it's important here to remember the key principle of the Children's Act 1989, which sets out that the welfare of the child is paramount. It means that a child's right to safety and protection from harm overrides all other legal considerations. But how is the welfare of the child paramount if their imprisoned parent is using contact with them to manipulate or control other family members? Or if they say they...
Thank you for giving way. She's making a very powerful case, and she's obviously talking about people in prison, but I think we've probably all seen it in our casework at thankfully at a much lower level, where relationships have broken down and children are weaponised by one partner or another. I mean, I've always found it very strange that the fact that a father will not pay towards his children and their upkeep, but still has the same rights as someone who does pay. I've never understood why that is the case. I do know why it's the case, because the two are not actually seen to be connected. But I've always had the view, if you're not of someone who supports your children, why do you automatically think you should have exactly the same rights as somebody who does?
I entirely agree, and I think we've seen those cases where perhaps contact with the children will be supervised, so they'll have to go to a centre because of the relationship between the ex-partners, and it's the mother will be very fearful of being alone in the same room with him. But I've seen so many examples of when that has been manipulated, and they don't actually really want to see the children. They want to use it as a way of putting fear into the heart of the mother that's bringing the children along. So, as I said, until the laws around parental responsibility change, families will continue to suffer. As we've outlined today, suspending parental responsibility, at least on a temporary basis, for those who commit serious violent crimes would certainly be a start. The right to parental responsibility could then be reviewed and re-established if families consent and if new evidence indicate this would be appropriate. It's important to note that this isn't a matter, as I think has been said, of removing a prisoner's right to parental responsibility in all instances. It's about protecting children and families caught up in the most extreme circumstances. We need to consider it on a case-by-case basis. Caregivers need more input into the process of determining parental responsibility from the start. We need to see more training for police and other authorities in spotting the signs of coercive control within families. And above all, children's best interests and their safety must be put first. And I have had a number of meetings. It's quite difficult keeping up with personnel changes in this government, but I have had meetings with Minister for Justice, Minister for Children, and raised it in various debates about getting this data on how many children have a parent in prison. Because I just know anecdotally there's a huge number of them out there. And unless we can identify how many of them are there and find a way of recording them, we will never be able to give them the help and support that they need. So I'll conclude on that thing. I congratulate Jade Ward's family for fighting for this, and I really hope that today's discussion takes us a step further to resolving some of these issues we've discussed today.
Rob Roberts. Thank you, Mr Holloway, for calling me in this important and solemn debate. A pleasure to serve under your chairmanship once again, and indeed to follow the Honourable Member for Bristol East. I have to commend my constituency neighbour, the Member for Allen and Deeside, for securing this debate on such a vital issue for our Flintshire community. I'll also take this opportunity to butter him up a little bit and welcome the Minister to his portfolio, and feel sure that he is the right person in the right role at the right time to drive this forward and obtain the justice that this family and families across the country deserve. Mr Holloway, crime is one of those things that will always exist in communities. Whatever we do in society and whatever laws we pass in this place, there will always be various crimes of varying degrees of severity. And rarely, and thankfully it is rarely, there's a crime that the headline writers say has rocked the community. In August of last year, the Deeside and wider Flintshire community was rocked. This is North East Wales. This type of thing doesn't happen in our communities. And the words we use in this place to debate things are important. Erskine May tells us that moderate language is of utmost importance in parliamentary discourse, so I always do my best to keep within the boundaries of that principle, and I try to avoid extremes like evil and hate. When Russell Marsh, and for the record that'll be the last time I do him the courtesy of using his name in this speech, when he killed Jade Ward, the egregious act at her home in Shotton, the nature of his crime could quite easily and fairly be described as evil. In the aftermath of that horrific event, Jade's friends, family, and indeed our entire community could certainly be justified in having feelings of hate. It's fair to commend both the North Wales Police and the court system for bringing him to justice, as he was handed a minimum 25-year sentence in April earlier this year. With all the delays and issues that we hear about in our justice system, it was only 7 months for the whole investigation and trial and sentencing. And look, I say 7 months. A lifetime, no doubt, for Jade's family and friends. But justice was served and seen to be served swiftly. But was it? Of course, seeing this vile wretch of a human carted off for at least 25 years is justice in one respect, but a lingering problem remains. And it's this lingering problem that we must address. And it's at this point, Mr. Holloway, I must commend Mr. Duggan, the family friend who set up this petition. I'm not sure whether he's aware, but it obtained signatures from every single one of the 650 constituencies in the UK, from the far reaches of Orkney and Shetland off the north coast of Scotland down to St Ives in the south of England, on its way to more than 130,000 signatures, including 2,808 of my constituency in Delhi. And considering that Delhi's numbers for national petitions are normally in the low teens, it's a great indication of the depth of feeling in our community about the issue. Jade's sons are now in the loving care of her family. I don't think there's a single person among us, Mr. Holloway, who can comprehend not only having to attend the funeral of your child, as Jade's parents had to, but to have to somehow hold everything together in the aftermath to provide a stable, loving home for your grandchildren as well. Compound the difficulties of being faced by the nature of the crime itself with the fact that the perpetrator has rights. We hear a lot about rights in this building and how one person's rights are being infringed in favour of someone else's rights. In this case, the perpetrator's rights are being held as in some way having any relevance whatsoever. He has to be consulted, he can take decisions about where the children live, go on holiday, where they attend school, be kept up to date on their progress. Just to be clear, we take away parental responsibility in cases of serious neglect. We take away parental responsibility in cases of serious cruelty. What more neglectful action could there be than depriving 4 children of their mother? What more cruelty would we need to see than taking a young lady and murdering her in a brutal and vicious way while her children slept in their bedrooms next door? I read the government's response to the petition when it passed 10,000 signatures. And I echo the comments made by the chair of the Petitions Committee, the Honourable Member for Newcastle upon Tyne North, in expressing my disappointment with that response. I appreciate the sentiment that we already have means to take these steps in existing law. But as has already been mentioned several times, it's time-consuming, it's expensive, and puts more strain on an already impossible situation for the family to deal with. In the case in 2013, where parental responsibility was terminated, because the father had been convicted of violently attacking the mother, it took years to terminate his rights on something that would have been obvious to anyone with a modicum of common sense about them. In this case, we're talking about a violent murder. This should be an absolute no-brainer that the perpetrator should forfeit his parental rights immediately when convicted of the horrific crime. There can be no greater cruelty. He should play no further part in the lives of these children. And Mr. Holloway, if I had my way, he'd play no further part in society for the remainder of his natural life, as 25 years should really have been a whole life sentence for what he did. And people might think, you know, this must be something that happens so rarely in society. So I did a bit of digging. The House of Commons Library tells me that there were 542 homicides, murders, recorded in England and Wales in the 2020/21 fiscal year. In 414 of those cases, the relationship between victim and offender is known, and of those, 67 cases were recorded as being partner or ex-partner. So assuming that figure carries through to the others where we don't know the relationship, that's 87 murders per year between partners or ex-partners where children may exist. And just to be clear for the record, this isn't the number of confirmed cases where parental responsibility is a factor, just an estimate of the number of cases where it might be. potentially 87 cases a year where the nightmare of a murder is compounded by the additional cruelty of the perpetrator controlling the lives of the children from prison. It's absolutely unconscionable. But the statistics don't matter. I'd be making all the same arguments if it was one family or 10,000. The law currently leaves the status quo to persist unless a long and laborious process is carried out to change it. It simply requires a switch of priorities. Put the burden, as the Right Honourable Member said earlier on, put the burden back on the murderer. If found guilty, make the suspension of parental rights automatic at the date of conviction and make him fight to get it back, not make the family fight to block him. Social services and the local authorities will already have been intrinsically involved by that point, as it will inevitably be months down the line between offence and conviction, and the children will already be in the care of the remaining family or a suitable foster placement where appropriate. The law simply needs to change to give social services the power that it would have if, for example, both parents had died. Come back to the opening words of my speech. I tried to avoid extremes of language. In cases like this, though, where one parent has unlawfully killed another, the perpetrator should, for the purposes of parental responsibility, be counted as having died as well. Seems, Mr. Hollybone, to be a complete no-brainer. Rather than putting the family through a horrendous process of trying to get parental responsibility removed, re-victimising them and keeping a killer in their lives, we should automatically just remove the perpetrator. We need to bear in mind that according to the Sentencing Council, the starting point for the minimum time to be served in prison for an adult guilty of murder ranges from 15 to 30 years before taking into account any aggravating or mitigating factors. Assuming reasonably that in the vast majority of cases there will therefore be a minimum of 15 years in prison. And by that time most children are likely to be over the age of 18, I don't see any reason not to say that the parental rights should be taken away at conviction and never restored, unless there's a specific and significant reason to do so. My right honourable friend can work out what specific and significant might mean, but we shall leave that up to the law writers. But should the children then, upon reaching adulthood, decide that they want to have contact with the perpetrator, then of course that remains their right, because there'll no longer be an element of control over their lives. So in closing, Mr. Hollybone, the families of victims have suffered enough. There's no reason to prolong their suffering. I hear the comments of my honourable friend from Wrexham earlier, with some of the potential pitfalls that may occur with things like this, and this is one of those occasions where the unintended consequences can have wide-ranging implications. We do need to keep in mind the best wishes, the best interests of the children as paramount every time. That said, I believe this is a simple change, steeped in common sense, that could be made with a relatively short bill, and I implore the Minister to make it happen with all due speed.
Reeves.
Thank you, Mr. Hollybone, and it's a pleasure to serve under your chairship. I want to start by thanking Edwin Duggan for setting up this petition and the 130,000 people who have signed it. I also want to thank my friend, the Right Honourable Member for Allen and Deeside, for moving this motion, and the Petitions Committee for scheduling this debate on what is an incredibly important issue which members have spoken so movingly about today. The member for Delyn talked about the re-victimisation of the families. The member for Wrexham talked about the current system failing children. The member for Bristol East talked about the brilliant work of Children Heard and Seen based in her constituency. And every member from across the House has spoken about parental responsibility being used as a form of control and a continuation of abusive behaviour and the weaponisation of children. But finally, the Right Honourable Member for Allen and Deeside spoke so beautifully about his constituent, Jade Ward, and how she dedicated her life to her 4 sons. And he also comprehensively set out the legal framework that underpins Jade's law. As we've heard, at just 27 years old, Jade was stabbed and strangled to death in her home by her former partner as their children slept. When Jade's murderer was given a life sentence in April, the judge described the attack as merciless. Like my friend, the Right Honourable Member for Allen and Deeside, I've also met with Jade's mother, Karen, and father, Paul. They're devastated by the loss of their daughter. And as with all murders, their grief is without end. But as a close and loving family, they are determined to give Jade's 4 boys the best life that they can. But they're held back in this because the presence of Jade's murderer remains in their lives through his parental responsibility to the children, even though he is in prison for their mother's murder. Mr. Hollowbone, there can be few things worse for a child than to lose their mother to violence. But this trauma can only be magnified when the person who robbed them of their mother is their own father. Whilst we have no official figures on how many children lose their mothers this way, we do know that 2 women are killed by their partners or former partners each week. This is a tragedy. But these deaths are not random, they're not accidents, they're not an uncharacteristic loss of control by a perpetrator. They're all too often targeted killings taking place in the context of domestic abuse. Indeed, the most common time for a woman to be murdered by a partner is when she tries to leave. This is usually after years, sometimes decades, of coercive control, physical, mental, emotional, and sexual abuse. The act of murder is the abuser's way of taking back control once the woman has attempted to break free. But it is not always the end of the abuse. In cases where there are dependent children and the perpetrator has parental responsibility by virtue of being married to the mother or having signed the child's birth certificate, his rights towards the child remain. Even a life sentence does not put an end to the offender's parental responsibility. This means, as we've heard, he has a say in where those children go to school, if they need medical treatment, or if their carers, often kinship carers, can take them abroad. This offers the perpetrator another means of control through which they can continue their abuse. Indeed, in particularly harrowing cases, a father has been able to block maternal family members from gaining residency of the children, with the children sometimes ending up in foster care instead. The fact that once acquired, a murderer's parental responsibility cannot be suspended without protracted legal battles is an injustice. What greater dereliction of duty towards a child can there be than to rob them of their mother and burden them with a lifetime of trauma? The House will recall that every year on International Women's Day, my honourable friend, the member for Birmingham Yardley, reads out the names of women killed by men during the last year. It's perverse that in some of those cases, having removed the mother's right to life and the right to bring up their children, the father's parental rights are not automatically suspended. And what about the rights of those children? Many will have witnessed violence and sometimes the murder itself. But at present, they must be raised knowing that the perpetrator retains knowledge of and access to their lives. For some, this results in fear that they may themselves be in danger, and for others, this results in decisions being made not in the best interests to deprive them of opportunities out of sheer spite. Children Heard and Seen, a charity that we've heard supports children impacted by parental imprisonment, report that the continuation of their father retaining rights over them as being a significant traumatising factor in these children's lives. For families of the deceased, the instinct to protect these children from the same person who has devastated their family is strong. But so is the feeling of despair that they cannot keep that person from doing further harm. Jade's law would change this. It would reverse the situation in which the onus is on the victim's family to prove through protracted legal proceedings why the perpetrator's parental responsibility should be revoked. Instead, parental responsibility would be automatically suspended. The onus would be on the killer to go through the legal hoops to prove that they deserve that responsibility. And let me be clear, it's not about punishing perpetrators. The criminal courts take responsibility for that. It's about doing what is right for the children that are left behind, safeguarding their rights, protecting them from further abuse, and trying to give them the best possible means to thrive. Mr. Hollowbone, as Jade's parents have said before, they want to stop another family going through what they have been through. I pay tribute to their tireless efforts campaigning on this and getting this issue as far as they have. Jade's Law is a simple solution that would end this current injustice. And I'm proud to stand here today and say that a Labour government would put Jade's Law onto the statute books. Whilst nothing can make up for the loss of Jade, we can make sure she did not die in vain. We can make this change and ensure that the rights of children and the victim's family are valued over those of the abuser. I hope today that we have the government's attention and that the Minister will also commit to making this change.
Thank you very much, Mr. Hollowbone. And if I may, I'll begin by, of course, paying tribute to the Right Honourable Gentleman, the member for Allen and Deeside, for his work and the Petition Committee's decision to allow us the opportunity to debate this very important subject today. But of course I should, in that context, and I hope the Right Honourable Gentleman will allow me, in a sense, refer to him almost as the conduit for the work that's been done by Jade's family and by Mr. Duggan, and I pay tribute to him for his campaigning work on this hugely upsetting and challenging issue. And it was my honourable friend, I think the member for Delyn, who highlighted that the petition has attracted signatures from every one of the constituencies across this country. I don't know if that's unique, but it's a pretty high bar to pass to achieve that, and over 100 I know from my own constituency in rural North Leicestershire, which I think is reflective of the impact that this issue has had across the country and the strength of feeling among people from all walks of life up and down this country. And I'd also like to take the opportunity, if I may, to offer my most sincere condolences to Jade's family on the loss of their daughter, their mother, and to her friends on the loss of a friend in such horrific circumstances at the hands of someone who, like my honourable friend, the member for Delyn, I don't particularly propose to use his name. I know that the thoughts of everyone in this chamber will remain with Jade's family, and the Right Honourable Gentleman, member for Allen and Deeside, did something actually I think quite extraordinary. He managed to articulate incredibly movingly, incredibly clearly, in a way I'm sure I could not have done, the circumstances, the feelings of Jade's family and the impact that this has had. And it doesn't happen perhaps as much as it should in this place, in the main chamber, not always. In this chamber we sometimes, I think, adopt a perhaps more measured tone that perhaps does more justice to the subjects we discuss. But in that context I say to the Right Honourable Gentleman, and this is not about party politics, that his constituents are extremely lucky to have so dedicated and caring member of Parliament representing their interests. They do in the Right Honourable Gentleman. And for me, it's in a sense, it's with mixed emotions that I stand here. In one sense, I would like to say it's a pleasure to be back in this role for almost a year and a half, between 2018 and 2019. I was the Parliamentary Under Secretary of State for victims, for witnesses, working with my honourable friend, the member for Louth and Horncastle, in her role at the Home Office in commissioning things like the rape review and bringing forward the victim strategy, getting rid of the same roof rule for compensation, and looking at the victims' code in that context. And in that context, working very closely, particularly with victims of violence, and particularly victims of violence in the context of domestic abuse and coercive and controlling relationships. I'll continue that in a minute, but I will give way to my friend.
Very grateful for my right honourable friend giving way. I suspected Mr Holloway he was about to give us a reason that he wasn't able to commit to this legislation. So I thought I'd intervene to give him a few extra seconds to reconsider and think of extra ways that he might be able to squeeze it into a little bit of legislation somehow.
Well, I'm grateful to my honourable friend who seeks to gently nudge me. But in that time, working, in fact, across the House, in that when I previously held this brief, I saw, as the Shadow Minister, the Honourable Lady, has highlighted just the lengths that some people will go to in their attempt to manipulate, to coerce and to control. And even when someone, a victim or victim's family may be told they are physically safe because that perpetrator is in prison, that doesn't address the challenges they face about feeling psychologically safe in the nature of the way that some of these people work. And it's also important, I think it was the Honourable Lady, the member for Bristol East, who highlighted that, of course, children are victims too. Those who witness these events or who may not witness them in person but live with the consequence of them are also victims of the crime. Yeah, of course I will.
Well, and thank him for his kind comments. Would you agree with me that quite often these abusive relationships start off with the perception sometimes of the victim that the perpetrator really loves them, really cares for them, and that's why they have that controlling behaviour. That's why they tell them, I really care for you, so I need to monitor your mobile phone. I need to know exactly where you're going. And this turns into that abusive relationship. And I think we have known people in all our lives where we probably worry that their relationship is not on an even keel with their partner. So I think this is obviously one of the most tragic cases I have come across. But there are many other cases out there where this abuse is still there, is still prevalent, and could lead in the worst cases to what we have seen.
Well, I entirely agree with the point made by the Right Honourable gentleman. In the nature of coercive and controlling behaviour, in the nature of domestic violence and domestic abuse, as I say, we are dealing with people who are highly manipulative, and exactly as he says, in some cases will seek to, in a sense, try to make the victim feel as if they in some way bear responsibility, which of course in no way do they. The only responsibility rests with the perpetrator. So he's absolutely right to highlight that point. I should also say, Mr Holloway, in this context, that the issue, or the legal issue we are debating here today, falls under the ministerial responsibilities of my colleague, the Noble Lord, the Lord Bellamy, KC, who addresses matters such as family law and similar. But I think it is important that I am, not only because he's in the other place, of course, but that I am responding to this debate with my responsibility as well as victims minister, because there is clearly a read across in this space. The subject of parental responsibility is fundamentally important in this context, and one that can shape the development of and relationship with a child, and governed by the Children Act 1989, which the Right Honourable Gentleman and other members have highlighted. Parental responsibility refers to all the rights, duties and responsibilities of parents or carers towards their children, including such things as decisions on where the child should go to school, where they should live, whether they can go on holiday, and similar issues alluded to in this context. And that Act, and I'll turn to it in a little more detail shortly, and touches on a point made by the Honourable Lady, my honourable friend, the member for Wrexham, starts from the presumption that the child's welfare and the child's interest is paramount, and to a degree with an assumption that that child being with their parents or having parental contact and parental responsibility is the preferred approach in that context. As honourable members have highlighted, for example, legally, mothers automatically have parental responsibility, as do fathers. And while there are orders a court can make to restrict parental responsibility of parents where it's in the child's best interest, and depending on the circumstances of case, it isn't the case that that can be simply removed. And I don't propose to reiterate at length the legal context as set out very, very clearly by the Right Honourable gentleman. Throughout this debate, I've listened very carefully to honourable members' arguments for changing the law so that a parent convicted of murder of the other parent has their parental responsibility automatically suspended during the period of their imprisonment. And there is no doubt that this is a legally and emotionally complex and challenging topic. And I do sympathise with the view that more should be done to ensure the courts can better support bereaved families in circumstances such as these. But I do, and I hasten to add, this is my 11th day back in the Ministry of Justice, but in that context I do have some reservations, some of which the Honourable Lady, the Member for Wrexham, slightly alluded to in her remarks, do have some reservations that an automatic suspension, that reversal that the Right Honourable gentleman was talking about, the presumption, is, given the legal context of the Children's Act, necessarily the best way of achieving the outcomes sought. But I'll seek to unpick that a little in a moment. The Honourable Lady, the Member for Bristol East, we may not always, shall we say, come from entirely the same political perspective on everything, but I have to say, throughout my time in this House, her speeches, her contributions are always thoughtful and considered, as indeed, again, on this occasion, she was in her remarks. I will certainly look up, but I'd be grateful if there's anything she wants to send me on it, Children Heard and Seen, the charity she spoke of, because in a previous role in the Ministry of Justice, I was also responsible for pushing through the female offenders strategy, which sought to reduce the use of prison for short sentences, for minor offences, for women, particularly for mothers. And I suspect that, again, there is a shade across into the work I'm currently doing, so I'd be grateful if she could share that with me. Of course, I'll give way to her.
Happy to do that, and I can give them details of the previous meetings that we've had with Children Heard and Seen and the, I think it was the Prisons Minister and the Children's Minister. But just to flag up, actually, what he just said, although I agree with it, is one of the issues that Children Heard and Seen sort of are slightly railing against, because there is quite a lot of work done. The Honourable Member for Camberwell, and Right Honourable Member for Camberwell and Peckham, for example, done a lot of work on making the case. And my predecessor, Baroness Corston, done a lot of work on trying to ensure that women, particularly women with young children, are less likely to be imprisoned. But that, again, is prisoner-focused. And the difference between that and Children Heard and Seen is it's not about the prisoner, it's about the children and putting the children first. So there's a slight difference. Yeah.
Well, I'm grateful to the Honourable Lady. However, the context in which I said it was that the presumption behind that strategy was what was in the best interest of the child, that should be a factor taken into consideration. And what we were seeing previously, and I go down a slight rabbit hole with this, but what we're seeing previously were a number of women, mothers, being sentenced for what would be deemed relatively minor offence without violence against the person or similar, in circumstances where they did have a functioning relationship with their child, but that was at risk of being broken. So it was seeking to give a little bit more discretion around that to understand where it was a functioning relationship and where it might work more effectively, rather than being potentially the blunt tool that it had over some years become. And a final point for the Honourable Lady Member for Bristol East, she also asked about how many children have a parent in prison and the data around that. I don't know how many of my predecessors she's had this conversation with, but I will endeavour to see if I can, through my good offices, see if there is a way we can try and find that data out, because I think it helps add to the debate. I'll make a little progress and then I'll come to the Honourable Lady, my honourable friend. The Children's Act, as honourable members will know, starts from the presumption that the child's welfare, the interests of the child are paramount, and seeks to reflect that and represent that through the courts making those decisions and considering that interest, and then making a decision in circumstances where it comes into play. There are, as we've heard from Honourable and Right Honourable members, various safeguards already in place to protect children, but they have been set out, I think, by the Right Honourable gentleman around the use of local authorities and the private law orders available to family members in circumstances such as these, as well as the mechanisms that the courts can employ in restricting parental responsibility, and also in preventing repeat and unreasonable court applications and applications that pose a risk of harm to. So there is that discretion of the courts through the Commission's hearing to restrict the ability of a perpetrator, a convicted offender, from being able to use the court process in a vexatious way. And finally, I'll seek to set out perhaps what more can be done to support families in tragic cases such as these and the action the government's taken so far. Of course, I give way to my honourable friend if she wishes to intervene.
Just going back to the female offender strategy you mentioned, Minister, I understand there's going to be a pilot unit in Wales, a residential women's centre, and I've been a strong advocate to make sure that there is some sort of families unit in there, so as women progress towards the end of the sentence, they can be reintroduced to the family and learn about parenting skills with a view to, when they are released, a seamless transition back into the community. I just wonder whether the Minister could perhaps drop me a line. I don't know whether you know the answer, but if you do, that's great. Or drop me a line to see what's happening about that children's unit. Thank you.
Well, I'm very grateful, Mr Holbein, and I will answer briefly to avoid straying perhaps too far from the actual premise of this debate. However, although no longer responsible for female offender strategy, in that I will certainly ensure that the Prisons Minister is made aware of my honourable friend's point. But it does go to a point that actually I was coming to, which is a point also made by the Honourable the Member for Bristol East, that this is a case-by-case thing. There is no one-size-fits-all, that each case is different. And that, I think, is one of the reasons why there are reservations about the automatic presumption, rather than letting the courts actually make that decision, consider each case on its individual circumstances. It's important to note, in the context of the Children's Act, that it's the welfare of the child, as I've said, rather than the views or interests of any adult that is the uppermost consideration in cases that come before the courts. And in determining the child's welfare needs, the court will apply the factors set out in the welfare checklist in the Children Act, including the ascertainable wishes and feelings of the child concerned, the impact on the child of any change in circumstances, any harm which they have suffered or is at risk of suffering, and how capable an individual with parental responsibility is of genuinely meeting that child's needs and their best interests. In tragic cases such as this, where one parent has been convicted of murdering the other, the responsible local authority has a duty to protect that child and ensure they are safeguarded from harm. This may include initiating care proceedings to provide the child with a permanent or interim care arrangement, and those arrangements, of course, as has been set out, can include family members, such as grandparents, being granted parental responsibility for the child, for example, through the granting of a special guardianship order by the court. But it does need that involvement of the court, because under the principles of the Children's Act, but also of our laws underpinning principles, it's only a court that can restrict those parental rights and change them. When it is in the child's best interest and appropriate in the circumstances of the case, as I say, there are those mechanisms whereby the court can restrict the parental responsibility of a parent, but it must be done through the court. Yeah, of course, I'll give way.
Right, honourable gentleman is very generous with his time. I wonder on that point whether there's any mechanism, he'll know the means a lot better than I will, whether there's any mechanism to ask, for example, a bunch of family court judges or a bunch of high court judges, whether they would be in favour of making this automatically apply, where they said, if we hand down a conviction for murder of another parent, this will automatically form part of your sentence. Could we ask judges that and see what their opinion is, or is that not something that we do?
Well, I'm grateful to my honourable friend. He's kind in presuming that 11 days in I am as expert as I was when I had held this brief for many years, but there's a fair amount of it that I've continued to keep close to. It is challenging, recognising the independence of our judiciary and that very clear delineation between judiciary and politics, but we do routinely seek the views and advice of the judiciary, and I'll turn to something we maybe will do in that space in my remarks in a moment. Yeah, of course I will.
Giving way again. I mean, this all sounds all well and good, but the fact is it ignores the reality of where we actually are and what the family have actually been through. I mean, they have suffered the loss, in this case, of their daughter in horrific circumstances, and we haven't gone into today some of the actual detail. And to then ask them to effectively go through this again in order to get something that they, rightly, in my view, assumed would be the case anyway, puts them a hell of an actual strain on them. And I think in many cases, people may decide not to go down that road because they can't put themselves and their family through that.
Well, I'm grateful to the Right Honourable Gentleman. He is, of course, absolutely right to highlight, in a way, as I say, that I would find difficult to articulate as eloquently as he does, just how horrific not only the original events were, but the possibility of reliving them, in a sense, one step removed, by having to go through a court process. We do, as I come back to the point, which I appreciate may disappoint him, but I may seek to move things forward a little in my remarks in a moment. But we do come back to that point in the Children's Act, 1989, which is the presumption that it is for a court, always, so there will always be an element of that court process necessary under the presumptions that were built into that groundbreaking piece of legislation. I would also highlight that under section 91(14) of that Act, the court can prevent a parent, it's something I allude to, can prevent a parent from bringing or making applications to the court without the court's prior permission, in particular where they're doing so may cause harm or distress the children of other parties involved in the case. So it may not entirely remove, but it does give the courts a route to seek to prevent the vexatious use of the legal process to try to re-traumatise or re-victimise a family, and it would be judges that would consider that and would have the power to prevent such an application where it was a sort of multiple application as to cause harm and upset. I have, as I say, heard the calls today to change the law so a parent convicted of murdering the other would have their parental responsibility automatically suspended during imprisonment. And I think the Right Honourable Gentleman characterised it as essentially a sort of reversal of the presumption in this case. And I have to say I am truly sympathetic, particularly given the case at hand. I cannot imagine anyone not being, having heard from the Right Honourable Gentleman and being aware of the circumstances of the case. But the courts do have currently mechanisms both to make orders to give parental responsibility to family members and significantly restrict it in appropriate cases, but always through the prism of their interpretation of the child's welfare and best interests. Every family is different, as is each set of circumstances that families find themselves in, and therefore our view is that it's important that courts continue to have that flexibility that the Children's Act gives them to make the decisions that are tailored to the unique lives of every child. The legal challenge to the concept of the automatic suspension is that it risks not aligning with the existing principles underpinning that key piece of legislation, the 1989 Act, and the way that it works. If we set up a mechanism to automatically suspend parental responsibilities in certain circumstances without affording the court the opportunity to hear all the arguments or evidence in the case, there is a genuine risk it would undermine the fundamentals of the framework in that Act. But I do recognise in situations where one parent is convicted of the murder of the other, the process of obtaining that legal redress, those orders that I've set out today, can be not only time-consuming, but that making or responding to court applications, attending multiple court hearings on related issues, can be psychologically horrendous for those involved and can re-traumatise people who are just beginning to rebuild their lives. I want to therefore outline two measures and an offer which the government is taking to improve matters for families in these circumstances. Now, I fear I may not go as far as the Right Honourable Gentleman might wish, but I hope it might be a further step forward. And I know him to be a reasonable man, so he may, without prejudice and without in any way residing from his clear view on what needs to be done, I suspect he may, and I hope he will take up the offer of these. Firstly, he will be aware that on the 17th of October we laid secondary legislation to expand the scope of legal aid to applications for special guardianship orders. It's an issue he highlighted around cost. It means where a private individual, such as a family member, wishes to become a special guardian, they can receive legally aided advice and representation to help with that. A successful application to be a special guardian will result in that individual having parental responsibility for a child or children. And secondly, having heard the arguments made today and having read and carefully reflected on the petition and the response that my predecessor sent to it, I will be asking the Family Procedure Rule Committee to consider what opportunities there will be for procedures to be expedited or otherwise adjusted so that in circumstances such as these, applications for special guardianship or other orders, as well as applications to restrict parental responsibility, can be made with as few procedural burdens and as swiftly as possible. It will be for the Rule Committee to consider that request, but it is a request that we will be making. This would have the benefit of maintaining the Children's Act and existing legal mechanisms and principles for courts to assess matters on a case-by-case basis, tailored to the child, but it will hopefully reduce the trauma and the burden that those processes can place upon people. In short, we believe it's right to limit the parental responsibility of those who hold it if deemed to be in the welfare and best interests of the child, and it's right though that is a power exercised by the courts and that they have those powers at their disposal to make these orders. I'm grateful for the opportunity to respond to the debate and to the Right Honourable Gentleman for securing it. The offer, if he wishes to take it up, and I suspect he's spoken to many ministers, is of course I will consider very carefully and further reflect on the points that have been made in today's debate, and will offer, if he wishes to take me up on it, to meet with the Right Honourable Gentleman, with the Lord Bellamy as the lead for family law in the department, and if he will allow me to join that meeting as the Victims Minister, I will be very happy to meet with him to further discuss the points that have been raised this afternoon and how we can best deliver on our commitment to safeguarding children and ensuring their best interests remains the utmost priority. Thank you, Mr. Holloway.
Hollowbone, and thank all members for taking part in the debate today. The member for Wrexham, Bristol East, Delyn, the Gower, and my honourable friend from Lewisham, Western Penge. That's correct, isn't it? Good, I got it right. And thank for the contributions made. I think it's been a good debate. I think we've addressed a lot of the issues. Clearly, I would have liked to see the Minister come here today and say, yes, we will do this and we will do it straight away. I recognise that these things never quite happen in that way, but I will certainly take him up on his kind offer of a meeting. I hope we can move forward in that, and I certainly welcome the comments of my honourable friend that a future Labour government would introduce this. I hope we can do it before. I hope we can do it before, because I don't see this as a political issue. I think it is an issue that the vast majority of people in this House and the vast majority of people out there actually believed needs to change, and it needs to change now. And once again, can I thank Jade's family and Edwin for all the work they have done to bring this to this House today. Thank you.
The question is that this House has considered E-petition 614893 relating to suspension of parental responsibility for people convicted of serious offences. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. Order. Order. The sitting stands adjourned. Thank you.
The proceeding has ended.